Jai Hind. I am starting a series of lectures on civil procedure code. There is always an apprehension and a fear in the minds of the students, even the lawyers, that civil procedure code is a very difficult and technical. To the best of my understanding, it is a very interesting subject. I'll try to make it simpler. I'll try to make it a subject which you may create an interest and follow in your pursuits of studies and the legal practice. This civil procedure code came into existence in the year 1908. Now, there is a myth that CPC governs the procedure in the court of law and it has the relevance only when we file a case in the court of law. I think this is a myth. This is not the reality. If you are drafting a civil suit, you have to consider the provisions of CPC while drafting the civil. If you will not take into consideration the provisions of the Civil Procedure Code while drafting a civil suit, while drafting a plaint, you may miss a lot of things and finally you may face trouble in justifying your claim. Now, while drafting a civil suit, let us take an example, Section 9. If it is not a civil dispute, how can you file a civil suit? So, we must understand what is Section 9 and what is civil. If some other civil suit between the same parties is already pending for the same subject matter, and you have been informed by the concerned party who has engaged you, can you file a civil suit? Or whether you are bound to disclose this fact or not, and what is the legal impact of that pendency of the civil suit. Section 10 will answer this, whether principle of res sub judice is applicable while filing a new case. You have to understand the principle. Similarly, take an example of Section 11, res judicata. While drafting a civil suit, your client has informed that the other party has earlier filed a civil suit and it has already been decided. Then you have to examine whether that judgment between the same parties operates as res judicata or not. So again, it is very important while drafting a plaint. Now you have to determine which court is competent to entertain and adjudicate the civil suit. Again, you have to understand the provisions, section 16 to 20. Where is the subject matter? Where the defendant is residing ordinarily? Where he is carrying on his business? Whatever those principles are there, we'll discuss in detail. So while drafting, you must understand which court is competent to entertain this dispute. So similarly, if a person is an indigent person, a pauper person not able to pay the court fees, you must understand the provision under the CPC, which enables a pauper, an indigent person, to file a civil suit without paying the court fee. You must understand those principles, those ingredients, those criteria to file a civil suit as an indigent person. Similarly, if the main party has already expired, whether you can file a civil suit on behalf of the legal representative or not. So, I am just giving few examples. So, you must understand the principles laid down in the Civil Procedure Code even at the time of drafting it. So, this is the first stage before filing the case. So, I have categorized this. So, before filing the case, we must understand each and every principle available on the statute. Then the second is now presentation of the plaint. There is a procedure. Then after the presentation of the plaint, there is a detailed procedure to be governed by the Civil Procedure Code. By presenting a plaint, then the court will issue the notice, how the notices will be issued, how these other parties will be summoned. If some person has refused to accept the summons, if someone has not been ordinarily summoned, what are the alternative methods? If someone has accepted the summons, how the court should proceed against that party which is not appearing. So there is a detailed procedure for summoning and dealing with the case. If plaintiff is not appearing after the filing of the case, how the court will deal with that situation. There are various contingencies, various types of procedures, which again the CPC will tell us. Now, the third is during the proceeding, first is before filing the case, then filing the case, and then during the proceedings, how the CPC will govern. And finally, the court will decide the matter in the shape of a judgment and decree. We'll discuss what is the difference between a judgment and decree. Now, there is a decision by the court, that is a civil court. It is again under the CPC. CPC governs what should be the judgment, what should be the decree. Then, if any person is aggrieved by this judgment and decree, they can file a revision or appeal, whatever is provided under the CPC. Again, the filing of the revision or the appeal is governed by the principles of procedure provided under the CPC, both substantive right to appeal, procedure, how to file the memorandum of appeal and how it will be dealt by the appellate court, be it the first appellate court or the second appellate court. So, in nutshell, all these stages we are always guided by the principles of civil procedure code. Now, in nutshell, because we have to discuss each and every provision of the CPC in detail as per the statutory sections and orders, but before understanding that, we must understand how the court proceed with the process. So, the proceedings of the civil procedure code by way of a plaint, when we are presenting before the court of law, that is called filing of the plaint. It is governed by different provisions of Court Fee Act also, but we are not concerned about that. We just understand how the procedure moves with the presentation. After the presentation of the plaint, the other party will be put to notice. It is called summoning. Then the other party may appear. Then the other party, we presume that the other party has appeared. Then the other party will file the written statement. Then after the filing of the written statement, the plaintiff will be given an opportunity to file a replication. Now the pleadings are complete. That is, the plaint, written statement, replication. Then the court will deduce what are the core factual and legal issues between the parties. Those are called issues. So the court will frame the issues and also describe which party is bound to prove its own, that is, the onus is on the plaintiff or the onus is on the defendant to prove a particular issue. It is, you must OPP, OPD. This is always written just after the end of a particular issue. OPP, OPD means onus to prove on the plaintiff, onus to prove on the defendant. Then ordinarily, I am saying ordinarily, the plaintiff will be given an opportunity to produce his oral and documentary. Now, after the closure of the evidence of the plaintiff, I am not going into detail how this evidence is to be used, when the chief examination, when the cross, that we will discuss in detail with the provisions. Now, the closure of the plaintiff evidence, thereafter, defendant will be given an opportunity to adduce its own evidence by way of oral and document. Thereafter, the plaintiff will be given an opportunity to rebut the evidence of the defendant. That is called rebuttal evidence. Now, after this conclusion, the court will finally decide the lists, that is the litigation between the plaintiff and the defendant. It is always in the shape of a judgment and decree. Civil suit always end in the shape of a judgment and decree. Then we say that the suit or the plaint has been finally adjudicated. So now this is the general process and the basic pointers where and how the civil suit moves in the court of law. Now with the provisions, I'll give a clarification, discussion, interpretation of various provisions of the Civil Procedure Code in the context of the provisions as contained in the CPC, as well as the law as interpreted by the Honorable High Courts and the Honorable Supreme Court. For this video, this is, I think, a sufficient introductory video for CPC. In the next video, we will discuss in detail each and every topic step by step. Thank you very much.